Thank you, everybody, for joining us on our January 2023. I got the year right, not the month, but the January 2023 webinar. We are talking about this sanctions order that we got last month in December of 2022. The case is Frazier versus Contour Eastwick. And we have a lot to cover. It's a 368-page order. So like the Republicans in Congress, we will start by reading every word of it along with the Constitution. So let us begin. Before I begin, actually, for Charlie, my 9-year-old in my house, you can see the switch right here. So Charlie was not behaving last night and sometimes watches these webinars. So I just decided to bring the switch into work. And I will play after this. I won't be doing any work. Nothing. I will be playing Mario Kart all day trying to beat her high scores. I hope that makes her angry. So anyway, but back to more important stuff. So what I thought we'd start with is a really quick, as best as we can, run through of this case, the facts of the case as quickly as we can, and then the litigation history, which is going to be the challenging part. This is not a shit on the other lawyers. This is not a shit on Contour Eastwick. That's not the goal of this. Our goal, and Alex and I talked a lot about what our goal was going to be about this today, because frankly, the other two options, those were high on my list, but we're not going to do that. I think the order is sufficient in that regard, but I do want to talk about the obligations that we all have as lawyers and that we all need to follow, especially in federal court. I want to make sure I highlight some differences between Georgia state law and the federal rules of civil procedure and why those matter, and why someone like Scott Masterson should probably learn that and stop threatening sanctions on everybody. But without further ado, what I was hoping Alex would start with kind of telling us the background of the case, and then we'll just keep rolling. As you guys have questions, I sent out that email yesterday asking for questions because this is such a mammoth of a topic and there are so many facts to go through. We're trying to balance telling you all about what happened, because I don't think most of you, if any of you, read the 368-page order. I'm going to be honest, I haven't read every word because in the middle, I got some PTSD as I was reading it. And I was like, oh shit, I already lived through this. Like I was reading the facts section is 200 pages or something. And I was like, I already know what the facts are. So I skipped a couple pages. So if you did too, we're trying to balance that. So if you have questions, drop them in the question, please. And we can do that. All right, Alex, you want to lead us?
Yeah, the case is pretty straightforward. It's like a lot of the cases we handled, a negligent security case. April of 2019, our client is asleep in bed at Eastwood Village Townhomes when a bullet comes through the wall and kills her while she's in her sleep. Something we see all too often, unfortunately. But we represent her survivors and her estate, and ultimately filed suit, I want to say June of 2020.
Yeah,
before I was here.
Yeah, shit started in August of 2020. So frankly, I'm gonna be honest with you. I think in this case, this was the best pre-suit demand my firm has ever written. It was the most investigatively sound, and I thought it was great. Chris Jackson, who now works for Alex Northover, really did the legwork at that time, and I thought the demand was great. And this was COVID. The demand was due at the end of 2019, and I guess no, that's a lie. We sent at the end of 19, and it was due. There was 2 demands, but I remember sitting there. I don't know if it was the first demand or the second demand. I remember sitting in my house and like counting the days till I was going to settle this case for the policy limits without having to file suit. Like it was one of those. I'm glad I didn't go spend the money. So it was really, really surprising to me. We got a first demand response, which asked us some kind of nonsense questions. And rather than file, we decided actually to give a second chance, which we did. And we answered the questions. One big question was, did the bullet come from the property? Well, as we thoroughly investigated and explained and have done so. The police did a bullet trajectory analysis and could tell you where the bullet came from, and it came on the property. And Eastwick's like, I mean, as big as a golf course. I mean, it's huge. So the chance of it not is very, very slim. And then there was an issue about whether she was an invitee. We were able to solve that problem. And it was a very strange response to the demand. And this will set the tone for what we're going to talk about. I guess I should tell you the underlying policy for the first $1 million did tender. So we were dealing with the excess policy and their lawyers pretty much from the start. I mean, they were the only ones that we ever really dealt with, minus Glenn Tornillo telling us his insured's going to pay, $1 million. So we're dealing with the excess lawyers, or the lawyers hired by them. And one of the best pre-suit witnesses we had was this guy named Wendell, not to be confused with Wendell Stewart. And he was a security guard there. He actually shot and killed a guy before this all happened. So we knew that he was a security guard because there's all these police reports about when he shot and killed someone while acting as a security guard. And the response we got from Contour, I'm going to call him Contour Eastwick, the defendant, was, that guy doesn't work here. We don't know him. Can you send us proof that he works there? Not only have we given them the police report pre-suit, we'd gone out and found this guy and got an affidavit from him. And I mean, it starts with, I worked at Eastwick from this date to this date. And that theme of, we don't know that, we don't know that's true. Can you prove that? Of basic information really, really, really sets the tone for how this case ultimately progressed. But I'll get us to where Alex joins in the mess. So this case is filed in state court, removed to federal court. Could we have kept this in state court? Probably. We probably could have. Looking back, I'm sure as shit glad we didn't. So because of the obligations and the rules and the ability of a federal court judge, especially on senior status, who takes an interest in the case, to spend 11 months drafting a 368-page order. But so we filed the lawsuit, and importantly, during the pretrial discovery planning process and conference, here's my first tip for all y'all. Don't just think of that as being boilerplate. That's not just nonsense, because the statement on there but both sides agreed to and discussed in our case, but I can see how it could just be left there from other previous plans you've written, is that electronically stored information will be searched and produced in the format that it was maintained in. What does that mean? That means you need to give me your Outlook files in Outlook form. You need to give me your documents in whatever document form they are, PDFs or whatever it is. And you need to, obviously, you recognize you need to save stuff. If we're already talking in the pretrial planning process about, your ESI and how we're going to get it and how you're going to save it and how you're going to produce it, ding, 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 you need to keep that stuff. So I think the best way to do this is we get discovery responses, and for the next couple of months, we really just go back and forth. There's a whole lot of back and forth about stuff. The somewhat standard, although it's still wrong, the somewhat standard improper discovery responses, vague and misleading responses, incomplete responses. So we're just really trying to sort out what happened. But let Alex tell you about the emails. Alex, how many emails did we get at the first couple rounds?
Just a few. Like,
well, how many's a few? You mean a few hundred? Few thousand?
Maybe a dozen. Maybe, I don't know. I would have to go back and look at the
I think it was
numbers.
6. I think it was 6.
It all kind of runs together at this point.
No, I think it was like 6.
It wasn't many. It was less than 10, I would say.
So we get less than 10, and then you're sitting there going, this can't be right.
Yeah, and I think one of the things that you just mentioned, and kind of one of the things that I really wanted to talk about, because I think it's something that can make all of our lives easier. I don't know how many defense lawyers are on here other than Shane.
There's a few.
But, one of the things that we have really started trying to do at the outset of a case, whether it's federal court or state court, is try to develop an understanding of, the other side's information systems. Where is all of your stuff stored? Because in an ideal world, you tell us we've got these email accounts and here's how we search them, and here's everything responsive that was in them. What ended up happening in this case is it's really seemed like there was a disconnect between, we understood more about the information systems of the other side than they did or that they would let on. And that's what led to a lot of these problems. And I can get into some of the case law. A lot of it was cited in the brief or in the order, I should say. One of the big cases that I would hope that everyone would go read, it's another lengthy one, but there's a case out of, I think it's Illinois, that came out 2021. It was DR Distributors versus 21st Century Smoking. It's another long sanctions order, but the judge goes through in painstaking detail about, at least in federal court, what is expected of litigants as far as understanding their parties' information systems, understanding how they work, doing proper custodian interviews, sending proper litigation hold letters and things like that. Because, I think that's really important, because I think it's something that it's 2023, everything is electronically stored, even, for the, I know some of the apartment complexes that Shane has defended, even their stuff is electronic. Some of it may not be, but they still have a lot of electronically stored information. And I think that everyone trying to do better, both plaintiffs and defendants, to try to understand this stuff from the outset can save us all a lot of headaches.
Yeah, and one way we've been doing that, we didn't do it in this case, but one way we've been doing that is a 30B6 deposition. We've talked about this before, but a 30B6 deposition of the defendant before we ever serve discovery. That's right off the bat, that is essentially tell us what you have and where it is and how easy or difficult it is to get it. And what our hope there is to, instead of having to go through the defense lawyer or to go through a trained corporate executive who's testified before or has a personal stake in the matter, we want like Steve in IT, or we want Brenda in records, because they're going to give us the honest answer. And that's what should happen. I mean, the other lawyer should be going and finding Brenda or Steve himself or herself and learning about the systems. Here, finding out what existed was painstakingly difficult. The first step of the process is, who are your employees? Who are your employees? It baffles me, frankly, how many times defendants claim not to know who their employees are when there's things like tax records, when there's things like payroll records. So I always get really frustrated when someone tells me that, they don't know who their employees are. We've had a lot of people over here in the last 8 years. I don't know if I could name every single person who's ever worked a day at my firm, but I know I could find out in like 20 minutes. And then 19 of those minutes is me spent trying to log into Paychex and like find my password and doing the reset. But I mean, the information is there. I think what happened in this case is, and we didn't mention this, but we'll share it. Our client had done drugs before going to sleep. And that was an issue, apparently, because the argument was that invalidated the lease because drugs weren't allowed, which I think is nonsense. That means if you leave your trash can outside on a Tuesday and it's not supposed to be there on Tuesdays, apparently your lease is invalidated or some nonsense. But I think that this case wasn't taken very seriously by the excess carrier from the beginning. And they always just thought, we're not in danger because of who the plaintiff is. But now they're in a situation, or they found themselves in a situation where they never really learned about their client. The lawyers never learned about their client. Alex, what are some things they could have done? And I guess I'll give the employee rundown, and then let's talk about some things they could have done. So at first they told us, and I'm going to get these numbers wrong because I've blacked this out now, but I think first they told us about how many employees was it? 19?
It's like 12, then 20, and
Yeah.
then ultimately there were 62 employees that ended up being disclosed in another case. I think the big takeaway there, and for some reason it seems like in some cases we have trouble getting an answer to this question when it seems very simple to just go to Paychex or whoever the whoever your payroll provider is and pull that stuff up.
What was it? Jory Jones, JJ? We were there were two employees. We were telling them
on that had, it was either LinkedIn or in their Facebook profile, and their initials showed up on a schedule that was given to us, and we asked, like, hey, who are these people? And they would tell us they didn't work there, and then come to find out they did work there for quite a period of time. I think that's one of the first things. Like we ask for payroll records, we get objections a lot saying that it's personal and private information, and that's fine. We're typically happy to enter in a protective order for that. I think if you're going to include people's protected information, it makes sense to enter into one for that. But in reality, we just want the names of people, and I think it's easy for a defendant to go and get that information and turn it over, and it's something that ought to be done, regularly. We had a quick question about the early 30B6, whether it's a Death Star Documents Depot. That's the name that Mark Kozorodsky, who's kind of the godfather of all this stuff, that it was been given to his notices. Yeah, it's based off of that. It is. I can't take credit for coming up with it. I can't take credit for even really revising it. I think it is a great tool for plaintiffs' lawyers to use to try to better understand the other side's information systems. I've started including more interrogatories asking about certain systems, and quite honestly, if I could get straightforward answers to those, it would probably save me from having to do that deposition. But until I get straightforward answers about it, I'll probably have to keep doing those. Meredith, you asked about, is there any difficulty in getting more than one 30B6 in federal court for the records stuff? I haven't had to have that fight. I've heard of it happening. Usually you can work something out to come back later and do a substantive 30B6. There's different ways to approach it, and I think if it is a case where there's a difficulty getting information about the information, I think you are better off taking that records custodian style 30B6, because that will give you way more of the answers, and you won't need to do a more substantive 30B6 later on necessarily. Or if you do, you can do it in a kind of a really limited scope to focus in on some things that you haven't been able to get answered through other corporate witnesses. That's my current thinking on it, probably subject to change at some point in the next, however long.
Well, and remember, under 30B, there's other options for taking corporate depositions. So you don't have to take a 30B6. Was it 30B1? I think it is, which is the title of a person. Forgive me if I'm wrong. It's not in front of me, but there are other ways to get corporate testimony. Remember, there's a issue about whether you can do discovery about discovery. A lot of courts say you can't, which is why we don't send discovery before doing the 30B6. That is the safest option, because you cannot, at least some judges have found, you can't do discovery about discovery. But the point of that 30B6 deposition is to hopefully get a witness who's not as prepared as they could be in terms of, when I say prepared, I mean in terms of the company, stance on the lawsuit. We don't really care about that. We just want somebody who actually knows where the things are. And then second, it eliminates a lot of potential objections. If Steve in IT says, Oh yeah, we've got all the payroll documents. We keep all the, we also keep all the 1099s, W-2s, but everything's stored through this system we have. Oh, Steve, how long does it take you to get that? Man, I can click around and show it to you right now. Okay, thank you, Steve. And then when you send the request for, and we make them very specific, please go on this system you talked about and download all that information and give it to us. You get an objection then, and we still do sometimes, but you get an objection that's unduly burdensome. Is it? How Steve said it takes 5 minutes, 10 minutes, whatever it is, good luck in a motion to compel dealing with that. And Mike Smith asked if we do the document deposition in state court. Yeah, we do. We've done it more in state court, frankly, just because we're there more. But under the federal rules, you as a defense lawyer have a duty to do what's called a custodial interview, or to make yourself aware as well as you can about what your client has. And that is a very serious obligation in federal court. And it's one that you basically can do it yourself if you do this 30B6 deposition, because it was extremely important to us, vital for us to be able to know their systems as well as them, and then use some common sense that I think the other side was devoid of, because there was a big issue about what email addresses existed and whether they were deleted or renamed. Rishi just asked, what was the trigger point that prompted us to move for an order compelling a forensic examination of the email servers? Well, we got a handful of emails at the start, and we got told that's it. Well, you go on their website, the apartment complex website, and you see their leasing office email. Alex had a great idea, and I thought this was one of the smartest things I've seen. You want to tell them what you did with evictions in apartment complexes? Because I thought that was great.
Yeah, we've talked about this a little bit on one of our previous seminars or webinars about investigating apartment complex.
Did you just downgrade this from a seminar to a webinar? I don't. Wow.
Yes. A lot of counties now on Odyssey have their eviction cases online. And it originally started as a way to investigate for prior residents who, chances are if they filed evictions against them, they're probably not happy with them. They're probably willing to talk to you. But what we found is that for some apartment complexes, and in this one, this is one of the places that we found emails. We were told that there's no indication that the owner of the company, that he ever talked to any of the tenants, and he had nothing to do with the property, and there's no indication that any tenants had his email address. And in searching through thousands of pages of eviction records or eviction files online on Odyssey, we find that there's one lady who has filed a answer and a counterclaim, and has her answer is 100 pages, and in there she included a lot of emails. And we found that after we had been told they don't have this is all the emails. We didn't search his email account because he wasn't involved in it, and here this lady is emailing him, talking about calling him on his cell phone or something like that.
Good old Pete.
And so that kind of triggered, we start saying, all right, well, what the hell? We're not getting all the emails. You need to search this. And so that's what kind of led us down the path of ultimately asking the court to order a forensic examination, which was ultimately done, and there were some other kind of, I guess, red flags, because one of the words that we were told had been searched was security, which would
we didn't do this intentionally. This was not, we thought about this later.
Which would security, it's a negligent security case. So naturally you want security searched. Well, when we get some of the emails produced, we start seeing, hey, everyone on this list has some sort of, your IT department puts some sort of disclaimer on your email. It turned out Contour's email signature, I think, had the word security in it.
And
So
so did all the,
technically
and
it
so
should
did every
have-
lease, and so did every lease, because the security
and so
deposit.
it should have triggered a lot more, which that later became, a different focus, because we were trying to then revise the search terms with ultimately the forensic examiner to eliminate a lot of these, what would be false, call them false positives or whatever you want to call it. But that was kind of a flag for us that we're not getting everything, or they're not searching it in a way that should be the way they ought to be doing it.
Yeah. And the question is, what was the trigger point? I will say we debated filing motions for months. I'll give us some credit here. I thought, unlike some other lawyers I mentioned earlier who just walk around threatening sanctions, I thought we did an amazing job of, I truly believe this, and I'll say this till I die. I thought we did an amazing job of showing restraint, of making sure we were right, and connecting all the dots from starting with the written discovery, confirming that as best we could, asking for what we needed at that moment, not getting 2 steps ahead. And what I mean by that is, if we just take the email issue, we knew we weren't getting all the emails. It just didn't make sense that there were only 4 emails or 6 emails, produced. Next step, we asked let's go backwards then. Let's go backwards then. We said to them, tell us who all the email accounts are. And we had our hell of a time. In fact, I don't know if we ever, to this day, ever got a real list of every email address that the company ever used. And they had told us that, what was the line, Alex? The best emails, because we wanted the property level emails. That was our goal. We wanted the property level, and we were only getting management level emails. What I mean by that is, we're getting managers, general managers, or vice presidents of this company. We're getting people in Michigan that there are. We're getting those people outside of Detroit. We want the people that were actually in Decatur. And we're saying, where are the property level emails? And they're pointing to some, but they're all originating from inboxes from people in Michigan. So we got what did they write in a motion that the best source of emails would be a certain person, right?
Yeah, we were told that the best source of emails would be this one person, and then it came to find out that she didn't work there at the time of the incident, and she was gone for, I don't know, I want to say like 14 months, about 6 months before and 6 months after our incident, roughly. And her pre-incident email address from when she left the first time was deleted when she came back the second time, which was well after, they were on notice that there was litigation, and that, they'd received preservation letters and things like that. And again, I think that a lot of this work and a lot of this stuff can be avoided just by trying to reach some mutual understanding at the very outset. Mike talked about the planning, the putting together the joint discovery plan in federal court. Me personally, I wish, in state court, we would have conversations like that, whether it's a formal thing or an informal thing. If we could just talk about it at the beginning of the case and say, hey, don't make me go take all these depots to figure it, like, just explain to your client, hey, I need all this information. There's some really good resources out there on conducting custodian interviews. And, a lot of us in this world, I don't have a background in, doing sophisticated corporate litigation. I've done PI work my entire life. I've done plaintiff's work my entire life. But I think that there are some people that are probably more advanced and more well equipped to do this type of stuff. But I've done a lot to try to educate myself about it, how custodian interviews work. There's a lot of really good resources, Sedona Conference, a bunch of e-discovery blogs that talk about it.
Where I used to work, Troutman Sanders has a whole, now it used to be a subsidiary, or used to be a department. Now it's a subsidiary, but it's called eMerge. I mean, so, you know,
Yeah,
like there's go take somebody to lunch if if you're having trouble with this.
because I think we're all better at the end of the day, we're all better served, even in state court cases, all of it used to be an apartment shooting 5 or 10 years ago, everything was paper files and, you went and dug around and found this stuff, but now there's so much electronic information out there, more tenants correspond, all the leasing office softwares that are used now you can send email blasts. Emails are associated to tenant files, text messages associated to tenant files. We've been going through this in another case, trying to get, and also, the defense lawyer there, fairly early on, went out and said, hey, there was an order granted compelling him to produce this stuff. And he said, look, I'm not competent. I don't know this stuff. This is beyond my, expertise. So we went and hired someone to go in and pull all this stuff for us. And to me, that's the right thing to do early on. I don't think it's too prohibitively expensive. I don't know the exact cost depending on what you're pulling and all that stuff, but it's something that ought to be discussed early on, so we're all not going through all of this, because I think that a lot of what ultimately happened in this case was kind of an unwillingness to understand all of this stuff and unwillingness to do what needed to be done.
Yeah. So to round out this email topic, our tipping point was we first asked who the employees are. We couldn't find that out. We didn't get it. We thought we knew, and we'll talk about the Mays case next in Gwinnett because this ties in. But we thought we knew. We then found out there were more employees. We were trying to figure out who had email addresses and who didn't, and what still existed. And at that point, frankly, we just weren't able to believe, because of a lot of reasons. We didn't trust the answer we were getting. It didn't make sense. For example, that they were deleting emails because of, on one hand, they're deleting emails, they say, when employees leave to save money. On the other hand, this woman left for 14 months and came back, and they were telling us she had the same email. That would be key in the judge's order later, or one key. So it just wasn't, it didn't make sense. They contradicted themselves about what their policies supposedly are. So we actually had a hearing about the examination, and we asked to know not only for a forensic search of the emails, but we wanted and obtained a forensic search of the GoDaddy account, because the GoDaddy account has listed all of the emails. It also lists what GoDaddy calls aliases. And I had a benefit here because we use GoDaddy, and I'm the one who creates emails and assigns them to new employees, or at least was before our amazing office manager Casey now does that. But I can follow an email address. Like Alex's email wasn't always Alex. It was some, I don't know. Do you know whose yours was before you? It was some, but you can trace it back. So we wanted to know, hey, you're telling us emails are deleted, but really were they reassigned? Because GoDaddy, you can't just cancel a GoDaddy email to save cost. You're signed to a contract, and it doesn't make sense. What makes more sense is to make it into a new alias. So we wanted an independent forensic examiner. The judge actually said during the hearing, kind of looked at me and said, "You sure you want? Because you're going to have to pay for that. They're offering to pay if you use theirs." And we agreed. And the forensic examiner that was used, who's a platinum sponsor of GDLA or some shit like that, and has it in his signature line, and was clearly an advocate for the defense. We ended up deposing him as well and asking him some fun questions about how his search, and he was ordered to do certain things that he frankly just either didn't do or did what I would call, I think this is a legal term, a half-assed job, just because he didn't, I don't think that it was helpful to, the people hiring him and paying him and who he had a relationship with. And I thought that hurt their credibility too, how poor the search was. One thing, for example, we talked about the leasing office email that's on their website, that got deleted. So, that got I don't know what happened because it's the claim on the other side was that email account was sold with the property. The property sold here during discovery, and they weren't going to access the email anymore, and didn't know the password. And one thing the judge ordered was to try every way basically that you can to get into that Gmail account, and they literally didn't even click forgot password until we asked about it. Until after the forensic search, they never clicked forgot password, and then tells you the last 4 digits of the phone number or something, the last 2 digits, and it'll still bother me. It also gives you a recovery email, and we counted the number of characters that were in the recovery email, and it fit perfectly for a certain, what I think to be very common and likely email that actually probably exists in the defendant's company. Let's talk about the Mays case real quick, because as I've said to everyone who's asked me about this case, we did really good work, but also we are the lucky beneficiary of the fact that there was a case, Mays is the plaintiff, in Gwinnett going on simultaneously, handled by a different plaintiff's firm, which was defended by the underlying policy's lawyers by the first $1 million. So Cruiser Mitchell defended that case until it was tendered eventually. But we eventually found out about the case when we knew about it. But once we started getting concerns, we were getting information from that case and comparing it. So easiest example, we were told that there's 11 and then 19 or 20 employees. And in the Mays case, there's 46 employees identified for the same time period. The only thing different between that case and our case was the defense lawyers. There was a big fight or big argument, and we got pushback about getting the financial records for this apartment complex, which, I think go to liability issues, but also punitive damages. They were willingly produced by the defense in the Mays case. Again, the only thing different is the lawyers. And if you follow like the Venn diagram, if you made a Venn diagram of, what's the same and what's different in the two cases, there's the information was very, very different. I mean, you'd have a corporate witness for the defense literally say one thing 1 week, and then the next week be deposed in the other case, whichever one it was, and say something very different. So we were really, really the benefit of having access to that information, which, if a poor kid wasn't, and I mean poor, like sad, this is bad, not socioeconomically, but, if the poor kid in the Mays case wasn't shot after ours, that wouldn't have existed, and we still probably would be pounding our head against the wall trying to get honest and complete answers and discovery. So we had that benefit, and it's also really scary to think about. If that case didn't exist, y'all can imagine it in some cases where you've had concerns or thoughts or worries, and there was no way for you to prove it. Here we were able to do that because a large part because we had this companion-ish case, related case that was going on simultaneously. Alex, what do you think about going to if y'all haven't read the order, by the way, starting on page 4, there is a table of contents that is, 8.5, 9 pages. It helps you pick out what you want to talk about given the beast of this. But I wanted to ask you what you thought about, we've talked about the reasonable inquiry. What do you think about, or want to give a rundown of Rule 37, the areas that we touched on through the lawyer's obligation with the certification, as well as some of the spoliation issues and things like that. And then I figure we'll end by talking about prejudice.
Yeah, without being too boring, talking about the different rules and everything, but I think, let me get the actual order pulled up here.
Yeah, here, I'll answer these questions as we go. Is it Draper of Relevant Technologies? Yes. Rob Draper is the person I am talking about. This is my filter. If y'all have some of y'all haven't seen that. I don't know if he's actually a platinum sponsor, but he's certainly a sponsor, and it's in his email. I could pull it up. I mean, it's like, I don't know why, if you're going to hold yourself out as an independent forensic examiner and tell the court you're independent, and that just seems not so smart. Michael Arndt said, counterpoint, would it be better to send form requests and get form objections and feign outrage back and forth? Something to think about. The problem I have, or the thing I get worried about, is sending form requests and getting form objections. We're just wasting time. And I am not trying to feign outrage. No, I know it was a joke on your part, but I think a lot of people do want to send the discovery responses first and then get mad about them. Like, I don't have time for that shit. Like, I just want the documents. And I think it also should.
I could do an entire like 5-part webinar on how pissed off I get at form objections and why they're complete bullshit. It's a waste of everyone's time. And since it's Mike's webinar, I'm allowed to cuss here.
Yes.
Please fucking stop. Please fucking stop doing it.
Yeah, it doesn't. I mean, I find it troubling that, the same lawyers on both sides will make form objections in state court, but not make them in federal court because the order the judge's standing order in federal court says you can't. Let's see. So let's talk about Rule 37 under the federal rules, and why we relied on those to get sanctions and what we had to prove. Can we walk through that?
Yep. Give me 1 second here. I'm pulling up all my notes here.
I'm looking at mine too.
There's a lot here, unfortunately.
So I'll start with Rule 37. E is the standard, or E is what's going to talk about spoliation. And Rule 37E requires you to find that there was a duty to preserve, that it was lost because the party failed to take reasonable steps, and here's probably the key: the missing ESI can't be restored or replaced through additional discovery. And the federal rules make it so that it seems fair. If you lost something, but there's still, the information is still out there in some way, shape, or form, that's okay. And here I talked about that I thought we did a really good job of filing our motions at the right point. What we did before filing our motions for sanctions, we filed 2 of them, was, number one, we made sure we were 100% right. You don't want to be embarrassed or have the facts wrong or not know them. But number 2, we tried to shut down every other avenue, which is why we went ahead and interviewed, Rob Draper, the forensic examiner, while we deposed him in a sort of official / unofficial way. It was transcribed without a court reporter, which is why we, searched out every email address and really focused on getting them to go through their GoDaddy account, which is why we had the documents from the Maze account. So, and why we locked in the defense as best we can. One, for the first purpose was because we were hoping just to get the information. The second purpose was to make sure we weren't going to go to court and they were going to say, oh, well, we found this. I have another case where I filed a motion for sanctions, or a motion for spoliation, and the resulting sanctions on the defendant. And, as soon as you find that, suddenly they found the EDR, the black box data. So I didn't want to be in that position. So that's Rule 37E, and that's what you're going to rely upon. There's a bad faith element to it, which is really the intent to deprive. That's the point of Rule 37E. It has to be the intent to deprive. And it's really just it should have been preserved, and you should have known to preserve it, or you purposely didn't save it. The part 4 of that analysis is that the affirmative act causing the loss cannot be credibly explained. And here, we don't frankly know what happened. We never saw a preservation of. We sent preservation of evidence letters, but we never saw a litigation hold letter. We never saw any documents from lawyers to their client or anything, which could come up in certain situations in spite of attorney-client privilege. We never saw, anything like that. And I don't know if that ever happened. I just don't know. But I know that during discovery, documents were destroyed and not saved. And had somebody like a Rob Draper been hired before and told to preserve everything, the defense wouldn't have been in this situation. We got to talk about the witness too. I just thought of that. That's probably what most people want to hear about.
We can touch on that. And I'll kind of just briefly explain it. There was we had been told that, kept being told that there's no one saw this. And long story short, come to find out that they did know of someone that at some point had told them that he saw what happened.
Oh, you got to tell everybody how you found him. You got to tell everybody I found him. So here, let me set it up. Let me set it up and you do it. So, because this involves rule 26, Federal Rule for Civil Procedure 26.
37C also.
Yeah, 37C and 26E1A. 37C1 and Rule 26E1A. It requires, and this is, I want to say this for two reasons. One, because this is important. Second, because it's a good story. But it requires 37.1 requires the party to supplement their discovery responses. 26E1A gives the teeth, is what the order said, if I remember right. So in 26E1A, you're supposed to identify all witnesses. Importantly, in federal court, if your response becomes incomplete at some point, you have the duty to supplement. In state court, by the way, you don't. Once your response is complete, it is complete unless it would basically constitute a false response. Or so remember, in state court, you got to ask the other side supplement. In federal court, you don't. That's a really important takeaway that I think a lot of lawyers confuse. But we asked them for any eyewitnesses. We also asked for a privilege log, and we never got a privilege log. At least we eventually did, but not at the beginning. And what happened was we had thought that there may be an eyewitness. We asked repeatedly if there was. We got told no, there wasn't. But in the police file, there was a mention. They were all audio recordings, and we had hours and hours and hours of footage, and we watched all of it. And in the recording, it talked about a guy who told a security guard at the complex that he saw the shooter and that he was driving, what was it, a Firebird?
Yeah. So
we started finding the guy. Yeah.
I'm sure for any of y'all who do these types of cases and have ultimately gotten body camera footage from the police, you know that one, it can be useful, and two, it is a gigantic pain in the ass to make useful. And what I mean by that is, generally, if you're taking these cases, and I actually listened to I see Mike Moran on here. I listened to a CLE where
different Mike Moran, but
good shout out
to that Mike Moran. I know of 3 Mike Morans in the Atlanta legal community.
Wrong Mike Moran. I listened to one where that Mike Moran and Pete and Andy Rogers all talked, and and I agree with everything about case selection here. And generally, one of the things that you got to have in order to really pursue these cases is very, very serious injuries or someone who's passed away. And what happens when someone passes away is there are a lot of police officers that show up. And so you can have days upon days of body camera footage, 4 hours of footage per officer, and trying to get through that is very overwhelming. You figure out that a lot of times it's 4 dudes standing around in a circle, talking to each other, and a lot of your body cam footage is the exact same thing. We got sent some requests for admissions, and I was going back through some body camera footage. This was in late 2021, I want to say. I have to remember the exact timing. This case consumed most of my life for the first year I was at the firm. And so going back through there, I came across a blue Firebird, and we ultimately tracked down the owner of that Firebird. And it turns out his brother did live at the complex, and we reached out to him, and he told us,
"Go fuck yourself."
Yeah.
What he told us.
I already told you lawyers I'm not talking to anymore. And we're like,
whoa. We didn't
wait.
talk to you. Whoa.
And so that's what led to us, uncovering this and us asking them about this witness. Come to find out, they ultimately had a statement of him. They had an investigator go out and talk to him. And we had never been told about this person.
Knew about him before we filed the lawsuit. So, they knew about them the whole time, and he should have been disclosed at lots of other points. When I knew we broke, I don't know, shit. When I knew that I thought at least this was, I thought there was some hope with the defense side when we finally, I thought we were going to get some cooperation, because remember we said to them immediately, who is this guy? Because we'd learned his name. And suddenly we got back a privilege log with him in it. And we got back his name. We got back whatever information that they had. And we said to them, I remember I wrote the email that said, give us the statement. You've waived privilege by not disclosing it all this time. And they agreed. And I thought that was going to be like, we're turning over a new leaf in this case. And that didn't happen. But I think that looking back, I think that's when maybe for the first time they got worried about what has been going on. I don't know. That has always stuck out, because that's the only thing we didn't have an argument about what the responsibilities of the lawyers were, or the clients, because that was just rather quickly, willingly given to us. And that always stuck out in my mind.
Responding to a question about Rishi's question about the judge's frustration over the inability to explain why they were not available. The frustration was apparent from the.
What was the question? What was the question?
About, was the frustration apparent at either of the two discovery hearings, or did it evolve afterwards from the judge and staff during writing the order? The frustration was very apparent from the get-go, and that's why. And
it's referenced in the order.
Yeah, and why I think it is, again, to keep beating this dead horse. It is imperative to really understand what is going on with your client's electronic information from the get-go. It will save us as plaintiffs' lawyers. It will save defense lawyers. It will save the court time. And we really all ought to try to do a better job on it.
Well, I frankly think we need to be broader, really. It's not just the ESI. It's if there's a companion, or I say companion, if there's another case going on with your same, witnesses, you got to go get those depositions and find out the answer. And then when your client says to you a different answer, you got to question them. I mean, you've got to, if there's a leasing office computer, you need to get and I guess this is the ESI part, but you need to get somebody to mirror that computer or take the computer. If there are hard files, you need those. I mean, you need to do all this, but the judge had some in the past, some other orders that had sanctioned Lockheed Martin, DaVita. DaVita was hundreds of millions of dollars, if I remember right. And he explained those at the end of the forensic examination hearing. He explained what happened in those cases and how he thought this case was trending towards that. I sat there. Alex and I sat next to each other, and I just kept saying, "Oh shit," in my head the whole time, because I had never heard anything like that. But then the sanctions hearing started with the judge listing the however many it was, 11, 13, something, the 11 or 13 ways in which we thought that they had violated different rules. And there was debate on our side about whether the judge said off the bat, because Alex was there, Chris Stokes was there, Alan Stagmeyer from office, we were all there. And there's still a disagreement about whether the judge said, and I'm considering granting these, and what that meant. But, from the beginning of the hearing, we felt really good. I will tell you, the scariest thing was the 11 months. That hearing was in February of 2022. And we waited, obviously until December of 2022 to get an order. There were I think I sent 2 emails in the middle asking, hi judge, is there anything you need? Or, you emailed the deputy. And we got back, no, nothing. And, it's very clear, writing a novel takes 11 months. So it makes sense now. Let's see. And other questions that I see are, I'm just reading the questions for the people who watch on YouTube, but what are the key differences in counsel's discovery obligations in federal court versus state court? You need to take, in general, you need to take a more active role in federal court when you sign certification for discovery responses. You're certifying that you as a lawyer have done the obligation, the things that you need to do. You have understood your client's systems. You have understood what documents existed. And that's where some of the lawyers here got in some trouble because they didn't. Alex, if we were in state court, what do you think would happen? I mean, we would have been let's imagine we're in state court. And this same stuff happens. What do you think happens?
I would like to think that the same thing happened, but I don't think it necessarily would. It's
why?
It's just a different.
Explain why.
So again, I can probably do a whole other some of my frustration with how some of the differences, but one of the things that frustrates me sometimes is, in federal court, you have deadlines, things get done, things get ruled upon, things get done in an orderly fashion, I would say. And so I think that, I would like to think that ultimately that we would have gotten to the truth, that this would have been the outcome after all of this had been uncovered, but I can't say for certain. I think that for better or worse, we may not have gotten to this point there.
Yeah, I think
I can talk about the dangers of federal court for plaintiffs' lawyers and your jury selection and things like that. But when it comes to discovery, I think federal court does things in a more orderly fashion, and there's
deadlines matter. Deadlines matter.
Yeah,
I mean, that helps. And there goes without saying, but their federal judges aren't elected. So, so judges who are elected in general have a vested interest in having both sides of a case, and all lawyers like and respect them. I'm not saying that necessarily influences their decisions, but I think at least subconsciously that has to, right? I mean, that's my 2 cents. I don't know how it wouldn't, but let me tell you about where we're going now and where we are in this case. So scratching my eyes because I'm been up the last couple nights, and so is Alex, because speaking of deadlines, we have a number of deadlines coming up. We are especially set for May 2nd in this case. It's a damages only jury trial. In our complaint, we alleged, obviously compensatory damages as well as punitive damages. So we won on both those grounds. I think that the sanction was appropriate because there really is no way to cure what happened. There really is no way. You take that eyewitness that they have a statement from and spoke to, and we never got that chance because the guy, we're calling him 2 years later, maybe even more than that. There were, I would venture to say, there were tens of thousands of emails that were destroyed. And at some point it got, if they told me that it was raining outside, I would literally have to walk outside and look and make sure it's raining, because I wouldn't be sure, and I couldn't trust that. So I think it was the right sanction. It has spawned us to very quickly change our focus in the case from the liability side, trying to win the case, to now this damages component. And we're moving as fast as we can. We have defense counsel on the other side, new defense counsel who's trying to get up to speed. We're actually going to lunch with them today to talk about the case, which is something we appreciate and we're happy to do. We like doing that kind of stuff. What I'll say is that there's been a lot of pushback. And Alex, I'll let you jump off here. I'm just going to give my little ending here, so I'll kick you out and you can go.
All right.
See ya.
Thanks, guys. Y'all have a good one.
Oops, I didn't kick him out. There we go. So I will tell you that every defense lawyer in the world now is threatening me with sanctions. Isn't that crazy? We get this order, and literally now I have almost every defense lawyer that I have for a substantive large case is suddenly, is trying to use this against us. And I think that's really fucked up. We are not lawyer headhunters. At my firm, we were trying to count the other day. I think we have filed 4 motions for sanctions in, 5 motions for sanctions in 4 cases. And one of them is this case twice. So that's the best bet that I've had. We've never had a reason to do it. In fact, we go out of our way because it benefits our clients to make discovery disputes and things that were wrong, that were done improperly, unethically. We make them about the defendant or the other side because that's what benefits us. Here, though, there was no way for us to separate. Well, I guess there was no way to separate the conduct. And in the instances we were able to separate the conduct between the defense lawyers and the defendant, there were separate obligations and completely separate sanctionable conduct. Hiding that witness that we talked about, the one that heard the gunshots and said he looked at his room or whatever and saw who he thought was the shooter walk where he walked. The client, the defendant, the apartment complex did not know about that witness. Only the lawyers did. So we were in a really tough position about what we were going to do here. And we struggled for a really long time about how we were going to present this to the court. Did we want to move for sanctions against the lawyers or not? And in our first sanctions motion, unless I'm mistaken here, and I don't think I am, we only moved for sanctions against the defendant. What happened and what changed my perspective on what we should do in this situation, though, was that one of the defense lawyers told me after one of the hearings, the forensic examination hearing, and said, we came to him and said, hey, we think there's more bad stuff. For instance, we think this is happening. We told him what we thought was happening. And the response we got was, basically, well, I don't know about that. You'd have to prove it. But hey, if you do, the insurance company is probably going to pull coverage. So stop, you better stop. And when that happened, I thought that wasn't, I just didn't think that was right. And then come to find out there was separate conduct by the lawyers, which is explained in the order, that their clients didn't know about, and their obligations were just simply not met. So here I felt like we had no other choice but to do that. I say that almost like a disclaimer, because I get these emails now, and I get defense lawyers, making snide comments that, oh, we sanctioned somebody. Well, first, no, I didn't. I'm not the judge. And second of all, I was put in a position, we were all put in a position over here that we didn't want to be in. I'd rather have had the information from the beginning. I still think, that information would be extremely helpful to us. That's why we pushed so hard for it. And I think we would have won the case regardless. We were deprived of that chance. And there's 3 promises I make to all clients, but the one that matters here is I promise clients that when they hire us, even if we don't win their case, we will find out more information than they can find out themselves, and they will learn more about what happened. I tell them that because, we are, through the discovery process, we are able to go through the discovery process and get things that no one else can get access to. And when the other side destroys that, they're not just hurting the case, they're hurting our client's ability to find out about the situation, which is something I promise. So, and I think that's why clients a lot of times file these lawsuits, not only to win, but also to find out more information and to have someone like a lawyer who can access information that isn't publicly available. That goal was frustrated here. And I think that's disappointing to the clients. So looking at on what basis are they seeking sanctions against you? Seems short-sighted, Carrie Burke asked. I've got one case where a lawyer saying that we didn't disclose a witness or something. I'm still trying to figure out exactly what I apparently did wrong there. I'll say I've never been sanctioned. I don't think I'm going to. New counsel by the anonymous attendee who asked the question is Weinberg Wheeler and Jack Hawkins and the good folks over there. this webinar was tough to do in the sense that we're trying to give you all some lessons, but also trying to tell the story. Hopefully we did a decent job of that. It's difficult to do without the frame of reference of what's happened. And obviously a lot has happened, which spawned a close to 400-page order. I think that the key takeaways for everybody here are, regardless of what side you're on, you should make sure you know about the information, the universe of documents that's available on both sides. So whether it's your client making sure that you have everything, or it's the other side making sure you understand how their business operates and what they save and what they don't and where it's kept and how easily it's accessible, those kind of things. I think that's the number one takeaway here. The number two takeaway is, unfortunately, if you feel like something is wrong, it probably is. It probably is. There, not to toot our own horn though, but I feel very, very confident that an overwhelming majority of lawyers would not have persisted for as long as we did, because it's gaslighting at its finest, right? You're told, we were told for months, probably more than a year, definitely more than a year. We were told that we were wrong, that we were crazy, that we were unprofessional for believing that they were not doing what they're supposed to do, that we were liars, that we had bad memories, that, all this stuff. And that, how dare we question what documents are available? How dare we continue to ask questions? And when we continue to ask questions, you ask something in an email, you list your 5 questions and you get responses to 3 of them. Then you follow up about the 2. And then you don't get a response to them, and you follow up and you get a response to 1. Now you're still left with 1. I don't think that, absent us being borderline lunatics about this case, that we would have gone down to the end of this road, and it would have incredibly hurt our client. So, at some point in that 11 months, right, as the 11 months is going from the time we argued this motion until the order, there are many nights where I sat up and said, am I fucking crazy? Like, is there something wrong with me? Like, am I just totally wrong? Are the other side right? Because, when you hear you're wrong so many times, it wears on you when you start thinking about it. It's, if it's similar, it's certainly not like this, but it's similar to the underlying premise of like a battered woman syndrome, right? You're almost abused verbally and told all these things. And at some point you're going to start believing them, but your intuition is probably right. The third thing, and this kind of goes to a question we got, but I'll mention it one more time, is that don't be quick to file a motion for sanctions. Make sure you've gotten all the evidence that you need, or what happened to it. Make sure you've tried to cross off every other bridge that, could we get other evidence? Couldn't we go here? Can it be found here? And make sure you make the case for the judge almost like an obvious conclusion, as opposed to you're still in the investigation stage, but you'd really like a sanctions order right now. I don't think that's going to fly in any court, because the sanction is so severe. Keep in mind, by the way, in our first sanctions motion, we didn't ask to strike the answer. We did not ask to strike the answer. And then we found out the conduct was tremendously worse than what we originally thought. So, another takeaway, I guess, would be to make sure that your sanction is tailored to the misconduct that you think. Originally we just asked, all the property level emails were gone. And there were some other things, but we asked, for a lesser sanction, which wasn't to strike the answer, because we wanted to tailor it to the situation. So if there's no other questions, this is the rundown. We tried to balance everything here. Here's another question. Here we go. You mentioned getting footage from the police officers in the case. What's the best way of getting discovery information from officers or even the DA, especially if the case is ongoing? So we, doing this kind of work for whatever's been 8 years now, and getting to know a lot of the folks in records department and the folks who are detectives and investigators and the district attorneys in certain counties, we, I think, are trusted. And we have had the luck. I mean, I don't know their point of view, meaning the police, why they give us some things and why they don't. But this case is a good example. There was a confidentiality order that the police required us to sign in order for us to get the police file. Everybody signed it. I'll mention the defense produced the police file to people without having them sign a confidentiality order, or might have produced. They produced it to somebody they shouldn't have. So we went out of our way to try to correct that for them and make sure that, sensitive information was kept. But I think that if you essentially present the police with a protective order and say, hey, we're promised we'll protect it, and here's what we'll do. That sometimes will work, but ultimately it's the police's decision. And, the civil case is always less important than the criminal case, and that's probably the way it should be. So there isn't a great answer, but being nice and asking and getting to the right person, maybe in the legal department or the DA's office, and explaining how the reasons for you getting the file and wanting the file are parallel and benefit the victim's family is usually a good start. Hopefully that helps you, Camille. I don't have a perfect answer because, there isn't one, unfortunately. Other than that, people, I think I haven't offended anyone in this webinar. I think I haven't said anything that's going to get me in trouble. Although at this point, I think 3 of my webinars over the years have been used in briefs against me, which is always fun. If you like the nonsense things I say, usually without a filter, I can't believe I'm going to say this. I never thought I would, but follow me on Instagram or TikTok. We put videos up every day. Have fun making them. I just made some more this week. But my goal in doing these webinars, and my goal in kind of the social media presence that I'm hopefully starting to have, is to show people lawyers are normal, honest, reasonable people who have a sense of humor and a personality. Things like this order, I think I'll remind us that not everybody is playing by the same rules. So I guess my last thing I'll say to everybody here is I'm a rule follower. I was as a kid, I still am, and violating rules really bothers me, like from a moral level. I think that's why I became a lawyer. And I'm convinced that I can beat you even if we play by the same rules, or so long as we play by the same rules. If it's a fair fight, make sure that you're doing that. You never want to jeopardize your client's interest because you've done something wrong. But maybe the most important thing that didn't happen and has never happened in this case is there was never a recognition by anyone involved who did things they shouldn't have done or didn't do things they should have, that they messed up. And I know it's tough to say that. I know it is tough to own up to something or admit that you're wrong. But I think there were a lot of opportunities, both on a professional level between lawyers and then with the court involved, for lots of people here to say, hey, sorry, we messed up. And to say, I don't know, as opposed to claiming things that were true or not true when you didn't really know. So make sure when you're talking to judges, you say what you know and say what you don't, almost like we tell our clients in depositions. And if you don't know, go find out the answer, as opposed to kind of shooting from the hip. So anyway, I hope this was helpful. This was a really tough topic from us, but we felt like we needed to. The next webinar will be in February, and we are going to do a little case recap. Two of my friends, Colin Barron and Brendan Flanagan, recently had jury verdicts that they were going to come and talk to us about the good and the bad. I thought that was a good thing. We'll talk about some cases we have. The next webinar, so you all know, is on February 16th at 9:30. February 16th at 9:30. I'll send the follow-up link. What I'm going to do is I'm going to send out the order to everybody if you haven't seen it. I will, if anyone has any questions or wants anything from me, for me to send in, my follow-up email that I'll do later this week, let me know and I'll include it. I appreciate y'all joining me. That's it. I appreciate you joining me. If you need anything else, let me know. We're always here. Happy to do these webinars. Thank you for everybody coming. This was fun. Yeah. So as y'all file out, I'll hang here for one more minute though, just to see if anyone has any questions. The Instagram is Georgia_lawyer, by the way. And the TikTok is just my name. The TikTok is just my name. The comments on TikTok are pretty amazing. Pretty amazing. All right, I think I got through all the questions. So thanks, everybody.